Okay, hello again. Once again, I'd like to apologize for the sound quality of the videos on Wednesday and Thursday. I have since switched over my recording stuff, and it should be a lot better. So what I'm going to do in this video is I'm going to give you just a basic sort of précis of what the Canadian Charter of Rights and Freedoms is about. We're not going to spend a whole whack of time on it because A, you did civics last year, and B, if you really want to get into the charter really in huge amount of depth, you should take the 12U law course. We do a whole whack of stuff on the charter. And this course is very much a survey course. So basically we are giving you a smattering of a whole bunch of areas of law in order to give you a grounding in all of them, right? I mean, the way I see the course is that the course is there to give you just enough information to keep you out of trouble in life, okay? So you should have done the charter scavenger hunt by now. This is just going to sort of flesh out a little bit, that out quite a bit more. And at the end, I'm going to give you a quick preview of what we're going to do later with regard to how you analyze a charter case, okay? Because there's a certain steps that you should take to do that, right? So one thing you need to remember is that the charter only applies to restrict the power of government, okay? So it doesn't apply when the person doing the evil thing to you is not a government actor. When I say government actor, you need to think of government expansively. So police or government, fire department, government, schools, government, libraries, government, universities, they receive public funding, so government, the government itself, right? So if any of those things are taking away any of the rights that are granted by the charter, you can argue the charter against those entities. But if it is a private person, a private company, or a private individual who are, say, for example, discriminating against you, you're not going to be able to use the charter. Okay, so it's important to remember that the Constitution and the charter itself only limits government. It only tells government what it can and can't do, not private parties. So, for example, say you go to, the coronavirus is finally vanquished, hopefully one of these days, and you decide that you want to go to the movies. So you go to Silver City, Brampton, just down the way there, and it's a Tuesday, and the people there say, "I'm sorry, it's no Brown People Tuesday. You can't go into the movies." Well, are you going to be able to argue the charter there? No, you're not. You're not going to be able to argue that you're being discriminated against on the basis of your race in violation of Section 15, which we'll talk about in a second. You're going to not be able to argue that. Why? Because Silver City Brampton is not government, right? They are a private corporation, private American corporation, okay? Now, don't panic, okay? Do not panic. Silver City Brampton can't do this. It is just, there's a different sort of weapon you're going to use against Silver City Brampton other than the charter, and that's called the Ontario Human Rights Act. So do not worry about the Silver City Brampton not letting you go to the movies on Tuesday. That's not going to happen, okay? The point I'm trying to make is that depending on what entity is doing the bad thing to you, you're going to have to choose different weapons to combat those things, okay? And we will do the Ontario Human Rights Act as well, so we'll give you an idea of what you can do if, for example, a Silver City Brampton or something closely akin to that ever does something like that to you. You do have remedies. Okay, so here's just a quick video, a quick overview of what the charter is basically all about.
Human rights and freedoms are essential for democracy to work. A democracy without human rights and freedoms is like a banana split without the banana, a computer without a keyboard. a bicycle without pedals, a game without rules. Since in a democracy it is the will of the people that gives the government its authority to rule, elections must be free and fair. And free and fair elections won't happen without basic rights and freedoms. In Canada, our rights and freedoms are protected by a document called the Charter. It's part of a larger document called the Constitution, which is something like a rule book that lays out how powers are divided among levels of government, the courts, and other institutions. Our Charter ensures that our rights and freedoms are respected and honored in all levels of government, in the laws they create, and in the programs and services they provide for Canadians. Our Charter guarantees certain freedoms for everyone. Freedom of conscience and religion, freedom of thought, belief, opinion, and expression, including freedom of the press and other media, freedom of peaceful assembly, and freedom of association. These freedoms are the seeds of democracy. They guarantee that we can express ideas freely in speech and in print, congregate with those who share our ideas, criticize the government, propose solutions to social problems, and publicly assemble in protest or support of political action. Remember, a democratic government remains in power only so long as it has the support of the people it represents. By contrast, for example, in Cuba, where there's an absence of some of these freedoms, such as freedom of the press, the same government has been in power for over 50 years. Our Charter ensures that every individual is equal before and under the law and has the right to the equal protection and equal benefit of the law without discrimination, and in particular, without discrimination based on race, national or ethnic origin, color, religion, sex, age, or mental or physical disability. However, this guarantee of equal protection and benefit does not prevent the creation of certain laws and programs that favor people who, historically, have not been treated equally. For example, federal and provincial governments have programs aimed at improving job opportunities, social services, and education for many groups that have been disadvantaged in the past. The Charter also protects your right to vote and run in an election, have a fair trial if accused of a crime, and be presumed innocent until proven guilty, have life, liberty, and security of your person, and communicate with the federal government in either of the nation's official languages. The courts of Canada, and specifically the Supreme Court, are responsible for administering our Charter. Using the Charter as a guide, the court decides what counts as wrongful discrimination and what counts as infringement upon your fundamental rights and freedoms. For example, it was a court that made a ruling which laid the groundwork for the legislation of same-sex marriage. It was a court that decided that a racist teacher in New Brunswick who was insulting and disrespecting the beliefs of his Jewish students could not use his charter right of free expression as a shield to continue doing so in a public school. It was a court that decided that people like Richard Sauvé, a convicted murderer, prisoner, and former member of Satan's Choice biker gang, still have the right to vote in elections. And it was a court that decided that school principals have the right to search any student's locker without a warrant if they suspect there are drugs or dangerous weapons inside. The Charter can even be changed and improved with changing times. There are two avenues. Our Charter changes a little bit every time a new ruling is made by the Supreme Court. The justices of the court refer to the Constitution and Charter as a living tree, rather than something that's frozen in time. They use the Charter in a way that allows it to adapt, accommodate, and address the realities of modern life. For example, as the lifestyles of gays and lesbians have become increasingly accepted in our society, the Supreme Court has adapted by recognizing our Charter rights and freedoms as a basis for legalizing same-sex marriage. Similarly, the court's understanding of our rights to privacy have changed since the dawn of computers and the internet. These types of changes are considered natural, just like a living tree grows. The rulings of the Supreme Court allow parts of the tree to grow. The other way for the Charter to change is by using the amending formula. the amending formula is the only way elected officials can change any of the rules of our Constitution, including the Charter. In order to make a change, the support of the Canadian Parliament is required, as well as at least 7 provincial legislatures, representing at least half of all Canadians. In other words, at least 7 provinces, including at least one of the biggies, Ontario or Quebec. So, let's say you wanted to add a new right to our Charter. Environmentalists, for example, have suggested that the Charter should recognize our right to a healthy environment. In order to guarantee such a right, the amending formula would have to be used. The Living Tree has many caretakers. The Canadian Parliament and provincial legislatures are responsible for adding and removing branches, and the courts prune those branches. Because the Constitution and Charter are difficult to change, they are a strong guarantee of our continuing rights and freedoms. At the same time, some people worry that they are much too difficult to change, even when there might be a really good reason to do so. Got more questions? Ask us in the comments. Don't forget to subscribe and check out our previous videos.
Okay, so there's basically 4 things I'm going to talk about. We're going to talk about them hopefully as succinctly as possible. First, I'm going to talk about the importance of Section 1, which is actually a very important section, along with Section 33. Those sections are sections that the government can use to actually limit your charter rights. Talk a little bit about the charter rights themselves in sections 2 to 15. Now, there are more important ones past 15, but they involve mostly language rights, French language, education rights, things of which aren't really things we necessarily need to address in this course. The third thing I talk about is the remedies section. What remedies can the court give you if your rights are violated? And then we'll talk about quickly how to analyze a charter case, although I will probably do that with you in person because that's probably the most difficult part of this whole endeavor. Okay, so how can your rights be limited by the government? Well, Section 1 actually limits your rights, okay? So Section 1 says the Charter of Rights and Freedoms guarantees rights subject only to such reasonable limits as can be prescribed by law in a free and democratic society. What does that mean? Then essentially it says that if the government is violating your rights, if they can demonstrate that violating your rights is a reasonable thing to do in a democracy, then they can limit your rights. Okay? So what Section 1 does is it balances your individual rights to exercise your religion, exercise your freedom of expression, exercise your right to peaceful assembly. It balances that against the right of society as a collective to make law for the public good. Okay? So basically the courts are just they're a big referee. They look at what your rights are, they look at what's good for society, and they come to a decision about what is reasonable in the circumstances. And there are a myriad number of subtests and sub-questions that you look at in Section 1 that the court will consider when determining whether it's reasonable to take away your rights or not. Okay, we're not going to get into those. That's more of a 12U thing, 12U law thing. We're going to just basically talk about, whether the law is reasonable. And there's a fairly easy example. The video mentions the racist teacher in New Brunswick, although I thought he was there. There was a case I know of is in Alberta. His name is Keegstra, and Mr. Keegstra decided to teach his history students that the Holocaust didn't happen. Remember the Holocaust, grade 10? Hitler. We talked about it a little bit in the last video. How Hitler tried to basically murder all the Jews of Europe. Keegstra said that didn't happen. And not only did he teach that in his class, he put it on the test. So if he asked you the question on the test, did the Holocaust really happen? And you said yes, you got that wrong. Okay? And he was charged with willfully promoting hatred under the criminal code. And Keegstra tried to argue that he had freedom of expression. He could say whatever he wanted in his class. And he failed miserably. Because although Mr. Keekstra has freedom of expression, Section 1 states that if the law is reasonable in restricting his freedom of expression, then the government can restrict his freedom of expression. And let's think about that. I mean, is it reasonable not to have Nazi teachers in the school? I think so. It's very reasonable not to have, racist Nazi teachers who, are trying to teach you Nazi stuff, right? There's a myriad number of reasons why that would be reasonable, right? We live in a multicultural society. Education is a public service. It's publicly provided, and it is reasonable in those circumstances to restrict what Mr. Keekstra says. Okay, so you don't have unlimited rights in Canada, right? Your rights are limited by Section 1. Okay, and we'll get into in the analysis section how that works. Okay, there's another section that they can use, the government that is, to restrict your freedom, and that is Section 33, the Notwithstanding Clause. Okay, the Notwithstanding Clause says that for a period of 5 years, the government, either provincial or federal, can basically ignore the fundamental freedoms, Section 2, and the legal and non-discrimination rights in Section 7 to 15. They can ignore those. So basically, they can make a law for 5 years that violates those sections, and the courts cannot review it, right? This was put in there because there was some concern that, democratically elected institutions like Parliament and legislature should be able to do what they want, which is kind of antithetical to the idea that you have a charter in which the courts apply to restrict government from doing whatever it wants. But it's a section. Luckily, I think it hasn't been used that often. It's a section that is used very, very, very infrequently, such that there's maybe one or two instances where it's actually been used. But it does exist. So if, for example, Doug Ford decided to build a wall around Brampton and make Brampton one big giant prison city, you wouldn't necessarily be able to stop him using the charter because he would use the Notwithstanding Clause. You would say, well, I'm being arbitrarily detained, you were retained without counsel, being retained without trial, I've been discriminated against, and all those things would be correct. And even if it wasn't reasonable to put up the wall, and it's probably not reasonable to put up the wall, okay? Even if it was an unreasonable violation of all of your rights, he could probably do it because of Section 33, which is very strange, but very true, okay? Second thing, what rights do you have? Well, the important ones we're going to do. Fundamental freedoms are in Section 2. Section 2A, okay? You have freedom of religion, right? So, if you sincerely believe in a practice that has a nexus with religion, and I'll explain that in a second, and the impugned measure interferes with your ability to act in accordance with that religious belief in a manner that is more than trivial or substantial, you can claim that your right to freedom of religion is violated. Okay, so. Well, you may be asking yourself, well, what is a religion? If I was a Jedi, let's say, there is some movement, I think in the States, to, make the Jedi people like, from Star Wars, make them a religion. Well, the law is that a protected religious practice need not be part of an established belief system or a belief shared by others. An individual need only demonstrate a sincere belief that the practice is of religious significance to him or her. So if you can convince the court that you sincerely believe that a certain thing exists and that you sincerely believe that it is a religious belief of yours, it qualifies as a religion, okay? So if I want to be a Jedi, technically, if I can convince a court that I sincerely believe in the Jedi religion, that's a religious belief, okay? Now, what if my religious belief believed in engaging in human sacrifice? Every Wednesday, we kill somebody. Would the law protect that human sacrifice as being part of my freedom of religion? Well, the answer is no. Why? Section 1. Is it reasonable to limit my religious belief that I need to engage in human sacrifice? Is that a reasonable limit in a free and democratic society? Of course, right? I don't think we'll get much argument about that. Okay. Second most important, or the second fundamental freedom is to be freedom of expression. Okay. And expression can be anything. Okay. So any activity or communication that conveys or attempts to convey a meaning is expression. Okay. So they're not going to look into what you're actually saying or communicating, either by way of speech, making a video, doing an interpretive dance and stuff, making an audio recording, doing semaphore with the flags or whatever. Doesn't matter. What matters is what you're doing have expressive content. Okay. If it has expressive content, no matter what it is, it's going to be protected by freedom of expression. Okay. The courts aren't going to get into whether, what you're saying is true or not, whether what you're saying is valuable or not, or whether what you're saying is harmful or not. Okay. Now, what about Nazis? Here we go. We'll go back to the Nazis again. What about Nazis saying evil stuff? Is that going to be protected by Section 2B? Might be, but it's going to get shot down in what section? Section 1, right? Is it reasonable that we shut Nazis down in a free and democratic society? I would think so. And the recent law has talked about something called the Charter Values Doctrine, in that your right to freedom of expression is going to be interpreted in light of all the other values in the Charter. So non-discrimination, democracy, freedom of expression, freedom of religion, all those things. Okay. So protecting people's freedom of religion and people's freedom not to be discriminated against is something the court is going to take into account in Section 1 to determine whether you have the freedom of expression to say what you want to say. This is really fairly important. And fundamentally, you probably understand this intuitively. Once again, we don't want Nazis running around teaching things like the Holocaust didn't happen or various other things that I'd really rather not talk about. Okay? Third thing is peaceable assembly. You have a right to participate in peaceful demonstration, protests, parades, meetings, picketing, other assemblies. What if you want to throw rocks at those? Well, it protects peaceable assembly. Section 1 will shut you down there again. It's probably reasonable in democratic society that I not throw rocks at the school if I'm demonstrating the fact that prom might not happen this year, right? I mean, I can demonstrate it. Can I, turn over Principal Cool's car and set it on fire? Sounds like fun, but probably very illegal and probably fairly reasonable thing to shut down pursuant to Section 1. Okay. Association, 2D, much like peaceable assembly. Peaceable assembly is more of a public thing. You're out in public. You're in front of the school protesting Mr. Price. That's fine. Association is the right to join others to form associations like unions, right to join with others in pursuit of other constitutional rights. So advocacy societies. So if you were pro-abortion person, you could join a pro-abortion group and that would not be prohibited, for example. Right to join with others to meet on more equal terms the power and strength of other entities. That's also something focused on unions. So the logical sort of basis for having unions is that your employer has so much more power than you do that it actually equalizes your bargaining power with that of the union, which is why freedom of association has been held to protect the right of people to form labor unions. What if you don't want to associate? What if you're like, screw that noise, I don't want to associate with people? You do have a limited right to not associate, but not in all circumstances. It's a little beyond the scope of this course to get into that, so we're not gonna. Okay, you have the right to vote. Surprise, surprise. Interesting though, only citizens can vote. Right? If your Uncle Ravinder is just in from Amritsar or whatever, and he's in town and he thought it might be fun to vote, being a tourist, that's kind of a touristy thing to do. Yeah, he's not going to be able to do that. You got to be a citizen. Now, mobility rights are guaranteed to citizens and permanent residents. You can enter, remain in, and leave Canada. You can come to Canada. You can go to Pakistan, come back, no problem. Okay. You can also pursue a livelihood in any province and take up residence in any province. The legal rights we will get into in criminal law in a week and a half. Okay. Timelines in this course, because of the Quad Minister scenario, are very constricted. So we're going to move really fast. You might have noticed this already. So you have life, liberty, security of the person. Okay. We'll talk about that. Right against being searched by the police and having your stuff seized. Notice that is unreasonable search. If it is a reasonable search, the police can do it. Right against arbitrary detention. So there must be reasonable probable grounds for the police to detain you if they're investigating you, okay, or they're going to charge you. You have a right to counsel. You have a right to habeas corpus. That's the Magna Carta thing we talked about the other day, right? You have a right to be produced before a court and have the Crown show cause as to why you should be detained. Otherwise, you should be let go. There are rights of those charged with an offense. For example, right to a jury trial, right to be presumed innocent, right to know as soon as reasonably possible what you're being charged with, things of that nature we will get into. Number 12, the right against cruel and unusual punishment. Yeah. Okay. So the government can't think of really awful things to do to you. Protections against self-incrimination. You have a right to silence, which means from the very moment the police are investigating you to the very end of the disposition of your trial, you have the right to say absolutely nothing other than identifying yourself. Okay? You produce identification, give them your driver's license, shut the hell up. That's all you need to do. Okay? And I'm going to encourage you to do that in criminal law. You also have a right to an interpreter in any kind of court proceedings against you. Okay? We'll get into these. Last substantive section we're going to talk about is section 15, one of the really important ones. Because what it does is it prevents the government from discriminating against you, either imposing a burden on you that you wouldn't normally have or restricting access to a benefit that you normally would get. Okay, that's under 15.1. So, the two things you got to ask in this situation with regard to section 15 is, does the Act create a distinction based on an enumerated, spelled out, or an analogous ground? Okay? What I mean by that is, are you being discriminated on any of these enumerated grounds here? The spelled out ones: race, national ethnic origin, color, religion, sex, age, or mental or physical disability. Now, what do you notice about those enumerated grounds? What's missing? Well, do you really think that the Charter does not protect gay and lesbian, LGBTQ people? It doesn't say that in there, does it? Or does it? Right? Well, it's not specifically spelled out, but it is something called an analogous or implied ground. The courts have said that the Charter protects gay and lesbian people and LGBTQ people on the basis that it is akin or like or implied in the ground of sex. Okay? So there are certain arguments you can make that even though you're being discriminated against, but you're not being discriminated against on any of these enumerated grounds, that there are some grounds that are implied. Okay, so residency status is another one that has been implied into national or ethnic origin. Okay, so there's two things you got to prove. One, are you being discriminated against on one of these either express or implied grounds? And is the distinction discriminatory? Okay, and we'll get into what that means with regard to the Human Rights Act. But you should know that the intent of the government in discriminating against you is not the important thing, it's the effect. So even if the government is trying to be really nice to you, if the effect of what they're doing is discriminatory, that's enough. Okay, well, so the Section 15 of the Charter protects equity, not equality. It's not about treating everybody the same. It's about the impact of what the government is doing on those people. Okay, and we'll explain a bit more about that when we see each other in person. Okay, 15.2 allows the government to discriminate sometimes. When's that? Well, if the government is discriminating in favor of people who have been historically discriminated against in the past, government can do it. So, for example, say Osgoode Hall, out of 200 first-year law positions in their first-year law class at the Osgoode Hall Law School, we reserve 50 of those positions for Indigenous people, okay? Because traditionally we haven't had a lot of Indigenous lawyers, right? They're discriminated against. Government can do that. I can't, run up to the court, white dude that I am, and say, well, that's just terrible. You can't do that. And you're discriminating against me on the basis of me being a old white dude. That's not cool. That's discrimination. You can't do that. Well, they can. Okay? They can under 15 sub 2, this one here. Okay? The government can try to fix stuff. Okay? And you can't, as a white dude, can't go run into the government to say, well, that's wrong. Okay? So that's an exception. Now, last thing I'm going to talk to you about, and I'm going to leave you alone a little bit. What remedies can you get if the government takes away your rights? Okay? So, you've established that the government is involved here, so the charter applies. You've established that that your rights have been taken away. The government has failed to establish that it's reasonable to take your rights away. The last thing you're going to look at is, well, what can the court give me? What remedy can the court give me to fix my problem? Okay, and there's a bunch of things they can do. What can they do? They can do whatever is just in the circumstances. Okay? They can do any... Sorry. Go back. Go back. Oh, not too far. Okay. They can fashion any remedy that is just in the circumstances. Okay? Generally, what do? They strike down the legislation in whole or in part. So if there's, for example, in the education, say Doug Ford makes a part of the Education Act, you can't have everything on your head. Nothing on your head in school at all. Nothing. Well, does charter apply to that? Yes. Doug Ford's government. Are your rights being taken away? Yes. One, your right to religion is being taken away if you're called a Sikh or you're an Orthodox Jewish person, right? Also, you might be being discriminated against on those bases as well. Make that argument. Is it reasonable for the government to do that? No, there's no real reason for that whatsoever. Okay, no. So the fourth thing that's going to happen is the court is going to make an order striking that law down. It's going to basically wave its magic wand. It's going to make a order, and it's going to say, that doesn't exist anymore. Doesn't exist anymore. So, you can wear your turban, wear your yarmulke, wear your baseball hat, whatever you want to do. Okay? Even though Doug Ford tried to stop you from doing that. Okay? Court's going to give you the remedy of striking down. So they can strike down the legislation in whole or in parts. They can suspend operation of the legislation so the government can correct it. They can read out unconstitutional parts and read in text to make the act unconstitutional. So, for example, this should be up here actually. The Family Law Act wants to define a marriage as between a man and a woman. The Supreme Court struck that definition down as discriminatory against gay and lesbian people. So the Supreme Court of Canada rewrote the legislation and took out the terms of man and a woman and substituted the text two people into the legislation. So they, the Family Law Act defined marriage as man and woman. That's discriminatory. So the good old Supreme Court of Canada takes out the eraser, erases out man and a woman, writes in two people. Okay, now it's constitutional, right? Man, woman, man, woman, man. As long as you got two people, you're married, okay? What else can they do? Injunction. They can make the government do stuff or make the government not do stuff. They'll only do stuff, make them do that where the court doesn't have to supervise the government too much. So there is a question of the courts taking into account the fact that their orders might not be workable. Okay. The courts can grant you damages. So the damages, say they shut your shop down, right, in violation of the charter, so you have all this lost business. Well, they can make the government pay you damages for the lost business that you lost when you were shut down because the government did something unconstitutional to you. Or other. They can do something else. Okay? As long as it's just and right and appropriate in the circumstances, the court can do it. Okay, how to analyze a charter case. Gonna do that with you in person. Okay, I've alluded to it so far, but I'm going to do that in person because it's a little tough. It's one of the harder things. So I want to be there. So if things are going off the rails, I can correct that as I go. Okay. So look through at this in the Google slide, but I will deal with this when I see you in person. Hopefully, I'll see you in person. Okay. Anyway, I hope you found this helpful. If you have any questions, pop into online class, or you can send me an email. That's fine as well. Hope you're well, stay safe, and I'll catch you next time.